All rise.
Further hearing in the appeals, Majesty's Treasury against A and the Queen on the application of K against Her Majesty's Treasury.
My Lords, my Lady, it now falls to me to open the appeal in my client's case. And before I outline my submissions, may I make three preliminary points? The first is that my client...
Wait just for a second. I'm so sorry.
Forgive me, Lord.
Getting
Of course.
notebooks and papers
Certainly.
out.
The first preliminary point is that my client also is subject to a direction by the Treasury under the terrorism order. And so I too challenge that order and adopt Mr. Owen's submissions in that respect without repeating them. We have made some supplementary submissions on the legal certainty aspect of that case. They're to be found in our printed case at paragraphs 68 to 87. And I propose to say no more orally about that issue. The second preliminary point is that my client is also subject to designation by the 1267 committee on the list maintained at the UN level, and therefore, through that route, is subject to the Al-Qaida order. And our submission will be that whether or not the terrorism order is ultra vires, in any event, the Al-Qaida order is, and the bulk of my oral submissions will be directed to the challenge to the Al-Qaida order.
Are you going to tell us, remind us where it is to be found? Is it in 18 or 19?
It's in volume 18.
Yes.
I will take the court to it in more detail in due course, but it's at tab 153. May I come back to it, my Lord, at an appropriate juncture and look at it in detail?
Yes. Thank you.
The third preliminary point is that, as the court will be aware, one of the distinctive features of the Al-Qaida order, in contrast to the terrorism order, is that it does not, on its face, allow a person to bring a case to court under the order. Originally, we did start the proceedings in that way, and I just wanted to remind the court that the way procedurally this difficulty was resolved, without objection, was that Mr. Justice Collins treated it as a claim for judicial review. And of course, it's not in dispute that if we have a substantive legal ground of challenge, we can challenge the Al-Qaida order by way of judicial review. That's, if reference is needed, paragraph 1 of that judgment at first instance. My Lords and my Lady, what I would like to do next is to refer to the one-page document, which I hope has been placed before the court, in which I have sought to reduce to writing, just in outline, obviously not in detail at this stage, the broad structure of the submissions I will be making. and we make these 6 points in outline.
Hang on,
Does my Lord have that? If not, we can supply
It's that sheet
copies.
which is, I think it's just on your right-hand side.
Just have some
Or underneath your list.
spares handed up. Well, we can supply a spare if anyone's missing it.
Share that just now.
Thank you. I hope that this, if nothing else, will reduce the need for taking notes and also will provide a guide to the later submissions I'll be developing. My Lords, my Lady, we make these 6 outline submissions. The first is that what is in issue in this case is executive action. And it is the action of Her Majesty's government, in other words, the British executive, not an international body. The second point is that in order to find legal justification for its action, the executive then needs to point to the Al-Qaida order. It cannot point to the UN Security Council resolution or the UN Charter, because on well-established principles, they are not self-executing in the domestic legal order. They are simply irrelevant and are not a source of rights or obligations in domestic law without enactment into domestic law. They may well be binding as a matter of international law, but that too is irrelevant to domestic law. I've referred to a number of authorities in this note. Unless I'm asked to, I won't go to them now. I will refer to them in more detail in my more detailed submissions. The third point is that the enabling power in the parent statute, that is Section 1 of the UN Act, will be read in accordance with the normal principles of statutory interpretation, in particular the principle of legality. General words will not suffice to confer a power to interfere with fundamental rights. Parliament's intention to permit such interference must be clearly indicated in the Act, and we emphasise this, that this is a principle of the common law and does not depend on the Human Rights Act. Fourthly, we say that there are at least the following fundamental rights in play, and we've listed 5. The first is the right to a fair hearing. Normally, of course, this would have to be afforded pre-decision. But as the ECJ acknowledged in Cardi, sometimes the surprise element is important. And my lords, my lady, we are realistic. Fairness, where it can't be afforded before the event, must be afforded after the decision, and duty is a common law authority to that effect.
This is a fair hearing of what precise issue?
My Lord, as the Court of Appeal and Mr. Justice Collins put it, in this case, it would be the factual basis for regarding my client as a terrorist.
Factual basis for putting your client on the list.
Yes, exactly.
And that's really the issue,
exactly,
isn't it?
Exactly so, my Lord. Exactly. My Lords, my Lady, the second right we suggest is in play is the right to property. The third is rights of privacy. Fourthly, perhaps this could be taken with 5, but for analytical purposes I suggest it's distinct from 5 in this sense, that the right of access to a court would apply even to a private dispute. Lord Diplock made that clear in some of the early authorities on the principle of legality as it's now become known. But fifthly, we make the additional point that there is here the important constitutional point that the citizen must have the right to challenge a decision of the executive in a court of law. In other words, what we call judicial review. And of course, my client is a British citizen, and he's been treated in the way that he has on British soil. My Lords, my Lady, our fifth outline submission is that this argument does not depend on European community law, but does derive support by way of analogy with the reasoning of the European Court of Justice in Cardi, to which I will return in due course. We suggest that reasoning is powerful and persuasive and should be applied in the context of our Constitution too. And lastly, we say this: the argument does not depend on the Human Rights Act. However, if we need it, we do have a distinct argument based on the Human Rights Act. We submit that the Al-Qaida order as subordinate legislation can in principle be struck down under Section 6 of that Act. And if I need to, and we've mentioned this in our printed case, if we need to, we will respectfully invite the Supreme Court to reconsider the decision of the House of Lords in Al-Jeddah. I will return to that. My Lords and my Lady, can I refer briefly to the international material. Much of this has already been referred to. I will take it very shortly. The United Nations Act has already been referred to. I don't take the court back to that. But may I just make these supplementary submissions in addition to what Mr. Owen has already said about the nature of the delegated legislation, which can apparently be made under Section 1 of the 1946 Act. I remind the court of what my Lord Pope said in the case of Stellato. The reference is volume 8, tab 63, paragraphs 10 to 12, where my Lord, if I may say so very helpfully, outlined the different levels of parliamentary scrutiny there can be in respect of delegated legislation. The highest is affirmative resolution procedure, then there's the negative resolution procedure. We have neither of those, although we acknowledge that we do have the third, my Lord referred to, which is that there is a requirement to lay the instrument before Parliament. And the fourth, my Lord mentioned, was where even that is missing. We acknowledge it's not in that last category, but we remind the court of a point made in argument yesterday, that what that means, therefore, is that the opportunity for parliamentary scrutiny is at the general level that my Lady Baroness Hale referred to yesterday, of political accountability in general terms to Parliament, rather than the opportunity to vote against a measure, for example. My Lords and my Lady, I do wish, if I may, to make some observations at this juncture about a point that my Lord Walker, I think, made on Monday, in comparing the scheme of this Act to the apparently broad powers to enact delegated legislation under the Human Rights Act and also under the European Communities Act. In response to my Lord's point, may I make these further observations to what Mr. Owen has said. Take first the Human Rights Act. There is a power in Section 10 by ministers to enact remedial orders in response to a judgment of the Court of Human Rights or a declaration of incompatibility in our own system. But there are important limitations, and it may be that because of those important limitations, the power has been sparingly exercised. No doubt I'll be corrected if I'm wrong, but personally I'm only aware of 2, perhaps 3 occasions when it has been used. Normally, the response to declarations of incompatibility has been for Parliament to be invited to enact primary legislation. The limitations are that the Minister has to have compelling circumstances to deploy the Section 10 power, and my Lords and Lady will recall that in Schedule 2 to the Act, Parliament retains an important role because the normal procedures of supervision in respect of secondary legislation are retained. There is the opportunity to vote down a measure, for example. And of course, there is a more indirect degree of parliamentary supervision in the sense that one of the functions of the Joint Committee of Human Rights is to supervise the process of enacting remedial orders. And the last point I would make about the Human Rights Act is that this, of course, is an example of where the executive is given delegated powers to improve people's rights, not to curtail those rights. May I turn briefly to the European Communities Act model? Like Mr. Owen, of course I acknowledge that Section 2 confers a potentially very broad power of secondary legislation on the executive. I don't repeat what he said, but I would just add this. We submit that this is the effect of 2 particular doctrines of community law. First, the doctrine of direct effect, and secondly, the doctrine of the supremacy of community law. Of course, that particularly direct effect simply has no bearing on UN law. That takes effect, if it does at all, at the level of international law, and I'll be coming back to develop that slightly. And finally, before I leave this point, my Lords, my Lady, we make the observation that there is, of course, an important scrutiny committee of the House of Lords, which again oversees implementation of EU measures by secondary legislation.
House of Commons as well, I think.
I'm grateful to be
But although
reminded.
I think
I'd
the House of
forgotten
Lords
that, my Lord.
does more.
Thank you. Thank you. My Lords and my Lady, may I turn briefly to the UN Charter? Again, I don't go back to it because relevant provisions are read, but for reference, it's at volume 18, tab 156. And I would just like to make this additional observation, picking up, if I may, an observation, I think, which fell from my Lord Mance during the hearing yesterday, that we would respectfully accept and indeed positively assert that the actions of the United Nations, and in particular the Security Council, should be read against the background that the United Nations itself is an international organization committed to the protection of human rights. That is one of its central functions and purposes as laid down in Article 1 in particular. But my Lord and Lady, we would suggest that the point can be developed a little further. We submit that at the international level, at the UN level, other documents that the court has already seen from Mr. Owen also illustrate this point, that when the UN acts, we submit it can be taken to act against the contemplation that when member states of the UN implement its decisions, they do so against the background that they will probably have long-established legal traditions and may well have constitutional guarantees. Take, for example, the call on member states of the UN to criminalize various conduct as being terrorist conduct. In my respectful submission, that call can be readily read and sensibly read as meaning a call to do so in accordance with the well-entrenched legal traditions of states. So many democratic states, I know not all states are democratic, and I know some states pay lip service to human rights, but many states are, like the United States, like the United Kingdom, well-developed democracies with legal systems and due process safeguards. So when something is to be criminalized, we submit it's unsurprising that states will criminalize things according to such things as having a court. There needs to be a court to arrive at a conviction. There will have to be such things as standard of proof to be dealt with. And if it happens...
Can I just pause there? It's rather interesting that Article 103 doesn't override member states' constitutional guarantees. I mean, one thinks of Germany, no doubt the United States.
My Lord is absolutely
France,
right.
And so forth. In our case, it's rather unusual because we can say, well, there are international obligations which the Human Rights gives effect to the Human Rights Act.
Yes.
But our constitution, you would say our basic fundamental principles are not affected by 103, would you?
My Lord, I do. My Lord, I do. And that's why, if I may say so, in our outline note, which I went to a moment ago, it's only at point 6 that we reach the Human Rights Act. I don't need it because I could succeed in this appeal, in my respectful submission, without the Human Rights Act. But, of course, I will address directly the point that we have to face up to, that if we need the Human Rights Act, then I am faced with the, on the face of it, adverse decision of the House of Lords in Al-Jeddah. But I'll come back to that if I may. My Lords and my Lady, what I would propose to do at this stage, if it's helpful to the Court, is to go briefly, as briefly as I can, through...
Could I just, before you do that, I'm terribly sorry, I was thinking about these two important points you've just made.
Yes.
The House of Lords said on more than one occasion that the rights in the Human Rights Act, 1988, were rights in domestic law.
Yes.
They were creating new rights in domestic law, albeit in the same terms as those that there happen to be under the European Convention of Human Rights.
Yes.
It would not be impossible, although one hopes extremely unlikely, for the European Convention on Human Rights to disappear, but the Human Rights Act
Yes.
still to preserve in domestic UK law
Yes.
the rights which it guarantees.
Yes.
In which case, your point about Article 103 applies.
Yes.
It could be said that it applies even though what we're doing is implementing our obligations under the treaty, because we've done it in a way that creates rights in our own law.
My lady is absolutely right, if I may say so, and I will come back to that. But the further observation, if I may say so, flows from, an important consequence flows also from the argument we make. It is not beyond the realms of possibility that the Human Rights Act may be repealed.
Maybe what? Sorry?
That the Human Rights Act may be repealed.
We've heard something about it yesterday.
But if that were to happen, I would still be entitled to make, and would make, the first 5 arguments on my outline page, because I invoke, first and foremost, the common law and the principle of legality in particular, which is a construct of the courts, and of course was developed long before the Human Rights Act, as the House of Lords made clear in Sims, which was a 1999 case. I do, if time permits, want to take the court later this morning to some of the historic cases to show how old a pedigree in the common law the principle of legality has.
Mr. Arrow, I've forgotten an awful lot about Al-Jeddah, but if my friend, if Baroness Hale is right, I mean, how does that square with Al-Jeddah?
My Lord,
it would be rather difficult.
My Lord, the analysis, may I deal with it briefly now?
Yes.
And of course I'll come back to it because it's important. My Lord, the analysis against me would go as follows, that although the rights in the Human Rights Act are domestic law rights, nevertheless, they should, at least in general, be interpreted in conformity with their interpretation in the European Convention. That's cases like Ola and Al-Skaini that my Lord is very familiar with. Therefore, in interpreting the domestic law right, it will be said against me that it can't go any further than it would be allowed to go in Strasbourg. And then you ask the question, how would it be interpreted in Strasbourg? And the answer against me is made, well, the European Court would interpret it in conformity with international law more generally. Now, we will quarrel with that premise of the argument, but that's what I think is certainly implicit, if not explicit, in the reasoning of the House of Lords in Al-Jeddah.
Thank
you. And that gives the answer.
Do we have the Northern Ireland case of P in the papers? I don't think we do.
I don't think we do, my Lord.
No, I think it does touch on this.
It does, my Lord is right. And if it's of assistance, we'll try and provide that, perhaps over the adjournment.
But in any event, there's a big argument about Al-Jeddah was about detention.
Yes.
In circumstances of either war or near war or immediately after war.
Yes.
And the point was whether Article 5 had to be read subject to an extension of the circumstances in which you can detain in the light of the UN Security Council resolutions. As I recall, that's what it was about.
That's right.
Whereas the principal right with which you're concerned is the right to a fair hearing and the right of access to a court to challenge the factual basis on which you have been put on the list.
Indeed.
It's not so easy to point to anything in the Security Council resolutions that demands that you be deprived of that right.
My lady is right, if I may say so. And when I get to Al-Jeddah in greater detail, I will be observing that even if Al-Jeddah is correctly decided, it should be given as narrow a reading as possible, for obvious reasons, because this concerns human rights. And I will be submitting that what Al-Jeddah acknowledged was that Article 5.1 had been modified to the extent that it was incompatible with the UN Security Council decision. It said nothing about Article 5.4. And your ladyship and certain other members of the House of Lords had things to say about what should then follow with fair procedures later on in that case.
That surprises me, that submission, though, because it seems to me the whole series of United Nations resolutions is designed to try to set up at the international level something which is a substitute for, though it's not actually, a court. And to suggest that the resolutions are consistent with a situation where the United Nations was saying, give effect to these resolutions, but nonetheless, every single country can set up its own national system for deciding whether our committee got it right, is seems to me very difficult.
Well, my Lord, it is difficult. That's why, if I need to make it, I make the submission that if I get so far as not being able to succeed on the common law, and of course I don't concede that at all, if I need the Human Rights Act, then at that juncture I will, if necessary, invite this court to depart from Al-Qaida. But may I come back to that? But what I was going to do now, if it helps, is try to go as quickly as I can through the Security Council resolutions relevant to the Al-Qaeda order. And I have marked it up in volume 19, but I'll try to give references also to page numbers in Appendix Part 2 in the G case. I'm told that it's Appendix Part 2 in the G case which has the fullest set of the resolutions, but in any event, I'll take them by number and give page references so that wherever the court has it, it can be looked at. The starting point is Resolution 1267, which is in at least two places. It's volume 19, tab 159, or it's Appendix Part 2, page 641. Page 641. Now, this was passed by the Security Council in 1999.
Sorry, hold you up, I think.
My Lord,
did you say 159?
159?
In volume 19.
Volume 19?
Yes, sorry, yes, I got it. Yes.
I'm grateful. And of course, the date is one which precedes the tragic events of 9/11. And at this stage, we see on the second page that the background in that noting paragraph at the top was the terrorist attacks on US embassies in Nairobi in Kenya and Dar es Salaam in Tanzania. And operative paragraph 2 demands that the Taliban turn over Osama bin Laden and brought to justice. Operative paragraph 4 calls on states, in order to enforce paragraph 2, to do a variety of things, particularly B, freeze funds and other financial resources, as we see there in more detail. Perhaps most important for present purposes is operative paragraph 6, because that established the committee, which has become known sometimes as the 1267 Committee.
Same as it is the Sanctions Committee.
And the Sanctions Committee. I should, in fairness to my learned friend, show the court operative paragraph 7, because that could be read as a notwithstanding provision. It may be, at least indirectly, a reference to Article 103 of the Charter. Taking these chronologically, then can I turn, please, to the next tab in volume 19, which is 160, also page 645 in the appendix. This is Resolution 1333, still before 9/11 in 2000, and the most important provisions are to be found on page 4. It's operative paragraph 8, and this calls on states to take further measures, including at C, to freeze without delay funds and other financial assets of Osama bin Laden and individuals and entities associated with him, note the words, as designated by the committee, including those in the Al-Qaeda organization, etc. And I invite attention also to the final 3 lines of this paragraph, where the committee is requested to maintain an updated list on information provided by states and regional organizations of the individuals and entities designated as being associated with Osama bin Laden, including those in the Al-Qaeda organization. So it has a continuing function and can respond to the calls of member states. Next, can I please turn to tab 164, which is page 658 in the appendix. This is a resolution 1390 passed in January 2002. The preamble refers to the situation in Afghanistan, determining that it constitutes a threat to international peace and security in the region. And the most important provision is on page 2, operative paragraph 2, decides that all states shall take the following measures with respect to Osama bin Laden, members of the Al-Qaeda organization and the Taliban, and other individuals, groups, undertakings and entities associated with them, as referred to in the list created pursuant to resolutions 1267 and 1333, to be updated regularly by the committee. And then A, in particular, is the freezing provision. May I then turn very briefly to tab 165, because Mr. Owen took the court to this. It's also page 661 in the appendix. This is resolution 1452, which of course introduced that possibility of licenses for basic expenses. Then I go to tab 166, which is also page 663 in the appendix. This is resolution 1455 of January 2003. It recalls the earlier resolutions on the first page, and then in particular I invite attention to paragraphs 1, 4, 5 and 8, but particularly paragraph 4, requests the committee to communicate to member states the list referred to at least every 3 months, and stresses to all member states the importance of submitting to the committee the names and identifying information to the extent possible of and about members of the Al-Qaeda organization, etc. And just to depart from the chronology of the resolutions for a moment, can I remind the court that, as later transpired, it was as a result of the United Kingdom government approaching the Security Council Committee that my client was placed on the list. Then, if I may, can I go to tab 166, forgive me, 168, which is also page 666. I'll really just note this, and unless I'm asked to, I won't go to it in detail now, that there are a number of resolutions that I'm passing over in the interest of time. There was another one in 2005, which is at tab 171, and is also page 672. At that point in the chronology, we get the listing of my client, because that took place in December 2006. So that's the state of the resolutions at the time when my client was listed. For the sake of completeness, I will show the Court two further resolutions, which bring us up to date. They are...
Sorry, so he was initially listed under 1617, was he?
Well, really under the cumulative body.
Under the cumulative,
exactly,
yes, but
exactly.
I see, it had reached that point.
It had reached that point.
What was the date again?
December 2006.
As I understand, I mean, he was listed the day after
The direction...
the direction was made against him under the other...
Exactly. I think the dates were 13th and 14th of December 2006.
Yeah.
In the chronology of the resolutions, because we do now have, in fact, a consolidated version of the earlier ones, and I'll just take the Court briefly to these, if I may. We then have, after my client was listed in time, tab 174, also page 683 of the appendix, Resolution 1735, and this, as I understand it, for the first time refers to the possibility of delisting. So it describes the procedure for listing at operative paragraphs 5 to 12, and then the Court will see on page 4 of this instrument, paragraphs 13 and 14 deal with the topic of delisting. And as I understand it, the resolutions have been, as it were, brought together in a consolidated version. Now, in 2008, that's tab 175, also page 694 of the appendix. This is resolution 1822. And
what's the significance, you say, of this one?
well, really, I don't need to go into detail on that, but what it does is consolidate the earlier resolutions in one place. And can I show, my Lord, for example, page 4, above paragraph 9, is the heading listing.
Yeah.
And similarly, page 6, above paragraph 19, is the heading delisting. And there's a topic of review and maintenance of the consolidated list from paragraph 24.
It struck me it was quite interesting to note in a different connection on page 695, reiterating about two-thirds of the way down, reiterating that the measures referred to in paragraph 1 are preventative in nature and are not reliant upon criminal standards set under national law.
Which part of the order, for those who are looking at it, not in the appendix?
So it's in the recital on the second page.
Yeah.
Yes.
1, 2, 3, 4, 5, 6, 7 down.
Yeah.
Reiterating that.
I have the point, my Lord. I have the point. My Lord, I acknowledge that. In fairness, I ought also to point out that this is dealing with all of the resolutions, including 1267 type resolutions, as well as 1373 type resolutions. Those are all recalled in the very first paragraph on the first page of this resolution.
Yes, the lesson, I mean, of the resolutions is that they are all expressed in, as far as I can see, in terms of identifying persons who are actually involved in the Al-Qaida or Taliban or terrorist operations.
Exactly so, my Lord. Exactly. Yeah. So that, I hope, is of assistance to the Court as a quick trot through the main resolutions relevant to the Al-Qaeda order. Can I go...
Can you just tell me that there's reference to a focal point?
Yes.
What is the focal point?
It's a reference to an international level opportunity for an individual to make representations, at least indirectly, to the Sanctions Committee. I'm going to come to that topic, if I may, next, and it may be clearer, my Lord, if I go to the guidelines which apply to the Sanctions Committee. They can be found in... There are two versions in the Court's papers. I'll go to the 2007 version and briefly refer to the 2008 more recent version. My Lords and Lady, the 2007 version is to be found in G's Appendix Part 2 at page 325. Appendix Part 1, I'm told.
Sorry.
My note, forgive me, my note is wrong on that. Page 325, towards the end of part 1 of the appendix. In answer to my Lord Phillips' question about the focal point, we'll see in a moment that that is directly dealt with in paragraph 8 of these guidelines. But before I come to that, can I just show the Court the broad structure of this document? These are guidelines in the February 2007 edition. It refers to the Sanctions Committee in paragraph 1, to the composition of the committee in paragraph 2. It's all members of the Security Council. Meetings are governed by paragraph 3. Decision-making is by consensus, that's paragraph 4A. If consensus can't be reached, further consultations take place.
Does that mean that when a decision's taken on the basis of consensus, the United Kingdom representative has agreed to it?
As I understand it, yes.
And if he doesn't, then the matter has to go to the Security Council itself.
That may well be so.
Well, I think that's what it says.
Yes. The mandate of the committee is governed by paragraph 5. It really reflects the resolutions we've now seen. And the consolidated list is referred to at paragraph 6, regularly updated, of course. Refers to information, relevant information received from member states. And we've seen that point more than once now. At paragraph 7 is a reference to updating the information from member states. And perhaps most important in this document, for our purposes, is paragraph 8. And essentially, as I understand it, my Lord, in answer to your question, the individual who is listed has, at this level, has two mechanisms by which he or she can make indirect representations to the Sanctions Committee. One is through the Foreign Office of the relevant state, so in our case, with the United Kingdom government, and the other is the focal point, which is referred to in subparagraph D, in particular. Well, B makes the point that you have the alternatives, and then D refers in more detail to the focal point.
I'm not sure I've grasped what the focal point is all about.
Well, no, Lord,
where is it?
Well, it's not entirely clear to us, if I may say so. It may be that my learned friends in due course can give more assistance to the court. We find it all, with respect, a nebulous body. The whole thing is opaque. We don't actually know who sits on this committee. They're certainly not judges. But of course, I hope I can be forgiven for making the point which we suggest is a realistic one, that in a case where it was the United Kingdom government that asked for my client to be listed, two things realistically can reasonably be thought to follow. One is that there's no practical point in asking the Foreign Office of this country to make representations that he should be delisted. And secondly, that if anyone did ask for that to be done, the United Kingdom would object to his delisting. And because it's a consensual decision-making process, there's just no realistic chance. Yes, I'm asked by Mr. Fordham to remind the court of paragraph 6 at page 327 of the appendix. I think he may come back to this in his submissions, but I'm asked to remind the court particularly of paragraph C at the bottom. And also over the page, paragraphs D and E.
Yes, C1 gets the same reference to moving as soon as you've got evidence, and you don't need to have a
Exactly.
criminal standard satisfied.
Exactly. My Lords, my Lady, can I give the reference to the latest version of this as we understand it? There is a 2008 edition, which is to be found in volume 19 at tab 176, but for my purposes, I don't need to go to it.
What was the reference?
Tab 176.
It's also 19. In Appendix.
It's not. That's
2.
not.
It's in Appendix 2 to the other, to Mr. Owen's case.
Right. Forgive me, I haven't got that reference.
Unfortunately, he doesn't have your guidelines, but he's got the others.
No, exactly. Now, at this juncture, can I turn to a very helpful analysis, if I may say so?
Sorry, is there any significant change in the 2008
No,
guidance?
it's a tidying up procedure, my Lord, as I
The
understand.
focal point has acquired capital letters at the beginning.
I'm sorry?
The focal point has emerged with capital letters as something rather more important, but still
whether it's become a
undefined.
more important institution because it has capital letters, I just don't know. But, my Lords and Lady, what I would like to do is show you the Advocate General's opinion in Cardi on this point. I'm going to come back to the judgment of the court later on, but the Advocate General's opinion has, we would submit, a helpful analysis.
This is Cardi,
of Cardi.
Yes, sorry. Yes.
Of the UN procedures and why, frankly, they are deficient insofar as due process is concerned. That's to be found in volume 13 at tab 105. And the tab 105 in volume 13. About halfway through the reported version is page 1238. 1238. And can I invite attention to three or four paragraphs? Starting in the middle of that page, paragraph 51, down to paragraph 54, and can I just highlight, obviously all of this can I hope be read, but for the sake of time, can I just take a few passages and highlight them? First, in the middle of paragraph 51, the Advocate General says, the existence of a delisting procedure at the level of the United Nations offers no consolation in that regard. And then another sentence on, he says, the processing of that request is purely a matter of intergovernmental consultation. There is no obligation on the Sanctions Committee actually to take the views of the petitioner into account. Moreover, the delisting procedure does not provide even minimal access to the information on which the decision was based, to include the petitioner in the list. And at the end of that paragraph on the following page, he states, procedural safeguards at the administrative level can never remove the need for subsequent judicial review. Yet the absence of such administrative safeguards has significant adverse effects on the appellant's right to effective judicial protection.
Haven't we got to read this in the light of the fact that Cardi was concerned with the position before a number of the resolutions you mentioned passed? I'm not sure that doesn't affect this. Admittedly, the court thought it didn't make a difference, but nonetheless, I mean, to be fair to the...
It's a fair point, my Lord, but in my submission at least, the material points in the process that I'm emphasising certainly applied at the time that my client is concerned and materially apply ever since. If there's any subsequent development which is not taken into account that renders the system truly fair, then no doubt my learned friends will point to that in due course.
I see from page 1220, footnote 1, that the Advocate General's opinion was January 2008.
Yes.
So it's comparatively up to date, really.
Comparatively, yes. It had just come out, if I recall, when the House of Lords heard the M case, which I think was February last year when the reference was made. So the House of Lords didn't have the benefit of the Court of Justice judgment. In the present cases, the Court of Appeal did have the judgment. As I recall, submissions were made in writing after the hearing had finished, but before judgment was given in October last year.
But the point is that the contested EC, or yes, regulation, was passed, and its validity depended upon the position before resolutions 1730 of December 2006, etc., were passed.
Well,
so that, I mean, that's the point in law.
That is right. Yeah. But I would respectfully say, my Lord, that what the Advocate General is doing, at least in part, in his opinion, is referring to the delisting process. And it is a continuing act at the UN level. And so the point, no doubt, was made in argument, I imagine, as is being made in this case, that there are some safeguards at the UN level, and what he's really pointing to is that they don't begin to satisfy what in a member state, certainly, and indeed in this context, the European Community Legal Order, would be regarded as basic due process. The principal one, of course, that's totally missing is the post-decision right of access to a court. And that's really the point he's making at the end of 51, also in 52, quoting from the Court of Human Rights judgment in Class. And that could be said equally of our common law for centuries, that point that the Court of Human Rights makes there. And paragraph 53 and 54. Time doesn't permit me to go through these at length now, but they're important passages. Yes. I'm reminded by Mr. Hermer that before I leave this, I should invite attention to footnote 52, where the original regime is referred to by the Advocate General, and then also the amendments in relation to delisting. I hope I've covered those in the resolutions when I went through them. Thank you. Yes. Yes, and of course, it is important before leaving this passage to emphasise the middle of paragraph 54 on page 1239, that the decision whether or not to remove a person from the UN sanctions list remains within the full discretion of the Sanctions Committee, and he calls it there a diplomatic organ. Now, these are not, as I understand it, pejorative terms. It's describing the reality of a political body with its own functions of consensual decision-making, consultation, etc. And what it's drawing attention to is that on any view, this cannot be regarded as a court as we would conceive of it. And that's not a criticism. And let me make this clear. We don't criticise the UN Security Council Committee, just as I apprehend it, the ECJ didn't criticise it. What they say is that if then decisions of such a draconian nature are to be given legal effect in the legal order of the European Community, then at that stage, the institutions of the European Community have to afford the basic human rights which are otherwise absent. And so it's a question of enforcing community law. We say, by parity of reasoning, read the words common law for community law, and exactly the same consequence follows, and the reasoning is very persuasive.
If, as in the case of Hay, the United Kingdom representative on the committee were to say, this man ought to be delisted,
yes, but
there's no consensus,
yes,
does the issue then go to the Security Council?
Well, either that or there's no delisting. And that's a factual scenario that Mr. Hussein is more closely concerned with, and he will no doubt want to come back to this point. But I'm, as you know, my Lord, I'm in the difficulty that my own government doesn't want me delisted because it asked for me to be listed. And I have to adopt the word used by Lord Justice Sedley in the court below. I know it didn't find favour with all members of the court below, but it is, I have to say, unnerving that if the Treasury is right in its legal argument, it may be, but if it's right, the consequence is that the British executive can take draconian action of the kind against a British citizen on British soil that we see in this case, completely bypassing the usual safeguards that our common law would afford, by approaching an international body to put someone on the list.
Assume they chose to do it by Act of Parliament. I mean, what form would this Act take? I mean, how would it deal with these problems?
I suppose, my Lord, for the purpose of our argument, it would meet the constitutional objection about how this is not within the vires of the executive in Section 1. If you had, let's say, something called the Al-Qaida Act,
Quite.
and it listed in a schedule the 1267 list people, that would meet the constitutional law objection. That might then raise difficult issues which the courts have not so far had to confront in this country about whether that actually is permissible or compatibly with the rule of law. But we're not faced with that situation. Here, it's the executive which suggests that Parliament, in enacting the general words of Section 1 of the 1946 Act, has given it the power to do this anyway.
I mean, that would, as you say, meet the common law objections, but it would instantly raise the Human Rights Convention.
It would.
I mean,
it'd be
if you're right in almost anything you say,
yes,
subject to the Al-Qaida point,
precisely,
there would have to be a declaration of incompatibility.
Lord, yes. And analytically, in terms of legal reasoning, I would suggest that that scenario my Lord puts to me would be analogous to the scenario in the Belmarsh case. So there would have to be a declaration of incompatibility. I suppose technically, well, as in the Belmarsh case, one thing that could theoretically be done is to have a derogation. But even a derogation, as the Belmarsh case illustrates, is not free of legal supervision. Ultimately, the courts are the guardians of the Human Rights Act.
But therefore, for anybody who subscribes to the convention, I mean, you're really saying that these United Nations resolutions are unimplementable.
Certainly they're unimplementable in an unfair way.
Well, but I'm asking you, how could they be made fair?
Well, my Lord, suppose, for the sake of argument, you had a prima facie list of people, but then you gave post-decision the right of effective access to the High Court. So what we don't have in Article 5 of the Al-Qaida order, what you have under the Terrorism order, which is an opportunity to put the case before a court.
Yeah.
Then you might, well, if Parliament wanted to take, my Lord, the control order regime, the observation has already been made that this is not radically different from a control order regime.
No, but that's all right if it's a domestic listing. But what happens when it's a United Nations listing?
Well, my Lord, this comes back to my fundamental point, that it is a UN listing, but if it's to be given effect in the domestic legal system, it has to be given effect in accordance with our basic standards of fairness, judicial review. There's nothing surprising about that, because that's analytically exactly the same reasoning as the ECJ uses in Cardi, which is that this UN resolution, if it's to be given effect in the community legal order, can only be given effect in accordance with the basic standards of fairness and judicial access in the community.
I wanted to ask you about that. In Cardi, the European Court in September 2008 gave 3 months to the community to put its house in order.
Yes.
What did the community do?
Well, Lord, my understanding is that what the Council has done subsequently is to take further decisions, having given some access to information, and that those decisions are now the subject of challenge in the European court system again. What the outcome of that will be...
But did it set up any sort of judicial system for reviewing the correctness of the United Nations designation?
I don't know the answer to that, my Lord. I suspect they did not, but we'll check that. I haven't heard of any such system. effective access, as I understand it, is being afforded by the opportunity to challenge the decision in the normal court system. But if we can provide further detail on that, we will. My lords and my lady, can I turn now to the Al-Qaida order of 2006, which is the instrument under challenge in this case. That's to be found in volume 18 at tab 153.
I'm not sure it is, actually. 153 is the terrorism order. Is that what you really mean?
So
I think it's 149 to 151.
Yes.
149 is the original order.
Yes.
But I'm not sure which one you want us to look at. Is it the 2002 or the 2006?
It's the 2006 one, which is
Which is 150.
50, yeah. Yes. I hope my lord will forgive me. There's a typo in my note, and I will change that now. Yes, just for clarity's sake, can I emphasise that it's tab 150 that I want to go to in volume 18. That's the unamended version. There's an amended version of it at 151, but for material purposes, I don't propose to go to that, at least at this juncture. Now, in structure, it's not radically different, except in one respect, important respect, of course, from the terrorism order. The structure is quite similar in the sense that you have a definition of designated persons at Article 3 of the order on page 4. And they include the possibility of a person who is not actually listed by the Sanctions Committee and is not Osama bin Laden, but can be any person identified in a direction. So the Treasury does have its own decision-making power under this article. And where they exercise that power, then the conditions for it in Article 4 have to be met. And there are procedural provisions in Article 5 and Article 6 which have to be met. So, and this is significant, of course, that the radical difference where it's not a Treasury direction, but simply a named person from the UN list, is that on the face of it, there is no access to a court, because Article 5.4 says the High Court, or in Scotland, the Court of Session, may set aside a direction on the application of the person identified in the direction. So, as I understand it, the argument against me is, well, that's all very well. There has been no direction by the Treasury in your case, and therefore you don't have the opportunity to ask the High Court to set aside anything.
That's on the basis that you have no relevant justiciable right to assert in any proceedings.
Exactly.
There's nothing that is capable of being reviewed.
Yes. Well, that's what's said against me. Can I just give our brief answer to that? It's fundamental. The UN listing had no legal effect in this country. What the Treasury did on the 13th or 14th of December 2006 is what froze my client's assets, including his social security benefits, in this country. And so both factually and importantly at the level of legal principle, what has had the draconian effect in the domestic legal order on my client is the decision of the Treasury. And that's why I started my outline submissions, my Lord, by saying that it is a decision of the British executive that we are concerned with. If matters had remained that all there was a listing of an individual at the UN level, that on fundamental principles of our law would have had no legal effect in the domestic legal order.
So are you really attacking Article 3.1b B? I mean, would it be 1A if it really mattered? If your client happened to be Osama bin Laden, but you're on a B case, and you're saying that shouldn't be there.
I'm not saying necessarily that it can't be there, but what I'm saying is that if it's to be there, then there has to be, at the very least, a right of effective access to a court after the event to afford the basic fairness rights that would ordinarily be required.
And for what purpose, though, given that given the designation? Is it to say, well, all right, there is a designation by the Sanctions Committee, but for reasons of our law, it's not something that could be put into effect?
Yes, well, that's right. Analytically, it's the analogue of CARDI. So for the purpose of community law, the designation doesn't have legal effect unless it's associated with fair procedures, including effective judicial access. So we would say the High Court has to be able to review the underlying factual basis for the allegation that my client is a terrorist. And that may entail, my lords and my lady, safeguards, a balance of procedures. One is now familiar from the control order regime with the concept of special advocates, in principle closed hearings, and things of that sort. Now, as I said to my Lord Brown earlier, if this were all done by Act of Parliament, it would probably, certainly for present purposes, I don't have to go any further than this, it would solve the constitutional challenge in our case. Of course, as in the control order regime, I know not, it may be that as the House of Lords held in AF number 3, that basic fairness means that it's very difficult in practice to operate the regime, but at least in principle, it would be compatible with our basic rights in the common law. As I said, my lords and lady, the structure of this order is then quite similar to what you've seen in the terrorism order. Article 7 is the freezing provision backed up by a criminal sanction. And then you have the exceptions and also the important provision about licenses in Article 11 of the order, and penalties are prescribed in Article 13.
Well, if there were an Act of Parliament that said all these measures could be taken in relation to anybody whose name was on the consolidated list, your only remedy would be to say, well, that's incompatible with the convention, wouldn't it?
Yes, absolutely, Lord. And that's, I think, I acknowledge to my Lord Brown. Yes, that's right. But as I say, we haven't got to that stage. Parliament has not enacted unfairness in this context. And the argument for the Treasury is and has to be that Section 1 of the UN Act has permitted the executive to decree unfairness. I say, on basic principles of our Constitution, Parliament has done no such thing.
I mean, will the Treasury not say Parliament has, to the extent that unfairness is necessarily implicit in implementing...
My Lord, that's right. That's the heart of the debate between the two sides. And like all cases that come before this court, that's the difficult issue that has to be resolved. We say this court should follow, in effect, the reasoning in CARDI, albeit in the community legal order. Of course, I'll come back to that. My lords and my lady, before I develop...
I'm sorry, can I just...
Of course.
I mean, do you say that there is no necessary unfairness implicit in the United Nations resolutions?
Well, my lord, I say two things. One, read narrowly, yes, that is maybe a strained construction, to use Section 3 concept, but that can be read, just as I said earlier, that when they say criminalise terrorism, they're clearly contemplating that you're going to criminalise it by reference to your existing legal system. So I submit it can be read, given the purposes of the UN to promote human rights and so on, when they say freeze the assets of this person, what they mean is freeze the assets in a fair way. Now, I accept that's a strained interpretation. If that can't be done, my submission then is, and it's a robust submission, that, well, that's all very well at the international level. They may well have chosen to enact unfairness at the international level. That's irrelevant in domestic law. It cannot be the source of domestic law obligations on my client. He's a British citizen facing the British executive on British soil, and yet he's handed a letter saying that all of his assets, including access to basic social security benefits, are frozen overnight. Why? Not even because there's reasonable suspicion, simply because of the fact of naming by an international body. And I have to say, my lord, and it's our robust submission, but it's right, we say, that that's all very well, but that simply cannot be given effect in the domestic legal order in this way.
I mean, just taking point 2 on your 6-point very helpful outline.
My lord, yes.
When you say at the end of paragraph 2 that these international instruments may well be binding as a matter of international law, but it's irrelevant to domestic law. I mean, isn't it relevant to the construction of Section 1 of the 46 Act, which is the domestic law we're concerned with?
Lord, Article 41 is relevant to the construction of Section 1 of the Act. I would accept that. But with respect, I wouldn't accept that the subsequent resolutions are.
I see.
My lord, my lady, what I'd like to do now, if I can, is just briefly touch on some of the facts of the individual case, because they really are telling, in my respectful submission, about how grave an impact there has been on my client's life.
Just before you leave that, it strikes me that your point would be much easier to see if we were sitting, for example, in the Privy Council with the Constitution of, let us say, the Bahamas in front of us.
Yes.
And you would see various articles that set out the basic fundamental law on human rights, and one would see that's a constitutional thing. 103 of the UN Charter doesn't affect that, you would say, and the constitutional rights have to be respected.
My lord, in response to that, it's a very fair question. Our response is that we too have constitutional arrangements in this country, including the principle of legality. I don't repeat what Mr. Owen has already said at this hearing, but I rely upon 2 principles in particular. One is the protection at common law of basic rights, including the right of fairness and effective access to a court to challenge in particular decisions of the executive. And secondly, his important submission, which I adopt, that there is an important basic principle of our legal order. It's something that Lord Brown-Wilkinson referred to in Pearson. Our constitutional structure, it has certain basic premises in it about who is the competent person to enact legislation of this sort. So, as I've said already, if it were the Al-Qaida Act, that then would meet the constitutional objection, although not the basic rights objection. Lords and Lady, as quickly as I can.
Do you really need to do this? There are findings in the Court of Appeal as to just how draconian the effect of this regime
Can I just give some references, my Lord, because there has been reference to the basic expenses license, and one thing that really affected my client was the delay in relation to the legal license. Perhaps I can just do it in this way, if I'll be forgiven, my Lord. The witness statement of my instructing solicitor, Mr. Carey, is to be found in Appendix Part 1 at page 130. And can I invite attention in due course to particularly the paragraphs where he describes the chronology between the 12th of February 2007 to the 4th of July 2007. I won't go to it unless I'm asked to by any members of the court, but can I outline what then happened?
Where does it begin?
My Lord, it begins at paragraph 8, and the chronology, the history, goes to paragraph 56, but I'm going to just outline in my own words, if I may, because of, quite rightly, my Lord's invitation to be brief about it. My Lords and Lady, what happened was that even the basic expenses licence took approximately 3 months to be granted. That was on the 15th of May, 2007. And that's paragraph 12 of his witness statement. And it did have to go. It had to be considered at the level of the Sanctions Committee, as did the question of a legal licence. And the court, I hope, will understand what I mean by legal licence is that before any money could be spent by anybody in this country, including the Legal Services Commission, to grant legal aid. In other words, my lords and ladies, the position factually was that the legal license took 7 months to be granted. It eventually was granted in August of 2007. In the meantime, the Legal Services Commission, fearful no doubt of its own position, asked those instructing me to take advice from the Treasury about whether they would be doing anything improper. And all they were prepared to grant was a conditional legal aid certificate, subject to a legal license being backdated subsequently. And if one just reflects for a moment on what that means, it's this, that the ability of a British citizen to challenge executive action taken against him by the British state in a British court and trying to invoke legal aid provisions in this country required approval initially from the International Committee and then approval through the means of a legal license by the Treasury. So in other words, the very body whose actions were under challenge had control of the purse strings. Now, as it happened,
just tell me, what issue is this going to precisely? What is the point?
Well, the point is that it's not only that this regime has an immensely draconian impact in practice, and my client, if I may say so, speaks eloquently to the impact on his daily life in his witness statement, but that it can have such a draconian impact that even the ability to launch a legal challenge is thereby made difficult by the very regime which is sought to be challenged.
I think this is one of the problems of Guantanamo Bay, wasn't it? Am I right? That, I mean, these people were outside the territory of the United States.
Yes.
And they had no access at all
to lawyers,
to any kind of due process.
Yeah. Well, that's right, save for this important factual distinction that we're here dealing with facts that took place on British soil. My client is a British citizen living here. And his assets, he speaks eloquently in his witness statement, I don't take time over it now, about the difficulties he's had, even once the basic expenses license was given, but he couldn't get a bank to administer his account.
I mean, it shouldn't have operated like that, is probably your primary, or one of your submissions.
Yes.
Was it integral to the United Nations scheme that it wouldn't necessarily operate in so draconian a way? Are you suggesting that in fact it should have been slightly more leniently or openly phrased, or in which case maybe the whole thing isn't under challenge, but simply particular provisions?
No, my lord, all I'm drawing attention to is that the way in which apparently it is supposed to operate, because in correspondence it was made clear to my instructing solicitor from the Foreign Office that this practice of what they call a hold being put on this consensual decision-making process. In other words, another state, unnamed state often, can put a hold on the basic expenses license and the legal license, apparently. The Foreign Office confirmed to my instructing solicitor that that was in accord of conventional practice. So they saw nothing wrong, as I understand it. This was the system working as it should at the international level.
There were objections to the grant of the basic license.
Yes. By an unnamed country. And I hope I'll be forgiven for using the word used by Lord Justice Sedley in a slightly different context. This is unnerving.
I mean, was there a period before licenses when you couldn't get one anyway?
Yes, yeah, before 1452 introduced the concept of the basic expenses license, you couldn't, exactly.
So, I mean, by definition, that was even more extreme.
Yeah. Yeah, as it happens, my client wasn't listed at that time.
No, I know.
But the point is a good one.
I know.
Yeah, the point is right.
I mean, as I understand it, we're not actually dealing with the individual facts of these cases. We're looking at whether the regime is actually itself violates the...
Well, we are.
So, I mean, whatever happened to the individuals, It's no doubt illustrative of the problems, but otherwise it's irrelevant.
It's illustrative of the problems. And before I leave this, can I just say this? Because he has been publicly said to be at least suspected of terrorism. The factual position, my lords and ladies, is this, that he was charged at one time with possession of items for terrorist purpose. He was acquitted after trial in this country in 2004. He's not been charged with any other offence, to my knowledge. He has not been the subject of a control order, and yet he has been condemned as a terrorist, put on the 1267 list. This was done without a hearing before, or, perhaps most importantly, any opportunity to challenge that designation in an independent court after the event. And that's why the legal problem that we do raise has arisen. We say that's illegal, therefore the Al-Qaeda order is ultra vires on basic constitutional principles. Can I develop that now?
So he was listed 2 years after he'd been acquitted, was he?
Yes. At the invitation of the United Kingdom government, supported by one other unnamed state. My lords and ladies, can I, in the authorities, as briefly as I can, because I know they're well known to the court, can I go first to the decision of the House of Lords in Rayner, which is in volume 3 at tab 18. In our printed case, we refer to this at paragraphs 39 to 40, and it's the well-known passage in the speech of Lord Oliver at page 499. At page 499, letter E, is the heading, the principle of non-justiciability. And I invite attention, obviously, to the whole of this passage up to letter D on the next page. But may I emphasise, first at F, it's axiomatic that municipal courts have not and cannot have the competence to adjudicate upon or to enforce the rights arising out of transactions entered into by independent sovereign states between themselves on the plane of international law. And then at letter H after the quotation, on the domestic plane, the power of the Crown to conclude treaties with other sovereign states is an exercise of the royal prerogative, the validity of which cannot be challenged in municipal law. And then after the quotation at B, this is the first of the underlying principles. The second is that as a matter of the constitutional law of the United Kingdom, the royal prerogative, which it embraces the making of treaties, does not extend to altering the law or conferring rights upon individuals, or I emphasize this, depriving individuals of rights which they enjoy in domestic law without the intervention of Parliament. Treaties, as it is sometimes expressed, are not self-executing. Quite simply, a treaty is not part of English law unless and until it has been incorporated into the law by legislation. So far as individuals are concerned, it is res inter alios acta, from which they cannot derive rights, and by which they cannot be deprived of rights or subjected to obligations. And it's outside the purview of the court, not only because it's made in the conduct of foreign relations, but also because as a source of rights and obligations, it is irrelevant. Now, in fairness, of course, I must acknowledge that in subsequent comments, certainly obiter comments and extrajudicial comments, certain members of the House of Lords, including Lord Steyn and Lord Collins, have expressed the view, at least tentatively, that so far as rights are concerned, that doctrine of strict dualism may need to be looked at again. But so far as I'm aware, so far as the obligations part of this is concerned, it remains a basic principle of our law, that the Crown cannot alter the common law by entering into a treaty or through some other international instrument which operates at the international level, unless it has the consent of Parliament to incorporate that measure into domestic law. So in other words, the source of the obligations on the citizen in domestic law will then be the statute. Now, of course, I acknowledge, and this is why we're here, the Treasury say Parliament has done that through Section 1 of the UN Act. We say it hasn't, and we invoke the principle of legality. That's why there's a debate. But I apprehend the fundamental principle is not in dispute. In relation to the principle of legality, my learned friend, Mr. Owen, has taken the court already to the important recent decisions of the House of Lords in Pearson and Sims. I certainly don't need to go back to Sims. Can I just briefly go back to Pearson to make the link to natural justice, to see how the origin of the principle really is deeply rooted in the common law. Volume 4, tab 22, and there are two speeches I would like to go to. First, the speech of Lord Brown Wilkinson at page 574. Can I remind the court, please, of letter A at 574, where wide powers of decision-making are conferred by statute. It is presumed that Parliament implicitly requires the decision to be made in accordance with the rules of natural justice. However widely the power is expressed in the statute, it does not authorise that power to be exercised otherwise than in accordance with fair procedures. This presumption was the basis on which this House held in Doody, and that's a reference to the tariff, well-known case about tariff for mandatory life sentences. And these requirements were not expressed in the statutory words, but were presumed to be imported into them. And then Raymond and Hani, seminal case about the prison rules and effective access to the courts. I, of course, place great emphasis on that, the decision of the House of Lords, acknowledging that there is a fundamental constitutional right of the citizen's right of access to the courts, and Leach is referred to at the bottom of that page on a similar point. So, my Lord and Lady, what I seek to emphasise, as I think, and I know will be well known to the court, is that not only is the principle of legality not new, it has a very old link in the common law to the right of natural justice and the right of effective access to the court. So those are the bedrock principles I rely upon in our case, and they're vouchsafed by a very old authority here being approved by the House of Lords. In our printed case at paragraph paragraph 5 and following, we've referred to these early cases. Can I give the references rather than take time now by going to them? Cooper and Wandsworth, of course, is the well-known 19th century case about natural justice. That's volume 1 at tab 3.
Sorry, your case, paragraph...
Paragraph 9?
9, yeah. Yes, sorry.
Yeah. The analysis, my Lord, is at paragraph 5 and following.
Yes, yes.
Cooper is at paragraph 9. And
well, we've got haven't we got these references in your printed case?
Yes, I think the volume number may not be there.
I see.
If there isn't, yes, it gives the tab number.
In my version, it doesn't have the volume number.
No.
If it's helpful, can I just give them? It's volume 1, tab 3. And of course, the well-known phrase by Mr. Justice Biles that for natural justice, positive words are not needed in a statute. The common law will supply the omission of the legislature. And Doody is volume 3, tab 20. I don't go to it, but your lordships and ladyship will recall the well-known speech of Lord Mustill when, at page 460, I think, he referred to the concept that if there can't be pre-decision fairness, then what there has to be is post-decision fairness. Here we have neither. On access to the courts, at paragraph 5 of our printed case, we've referred to a World War I case called Chester and Bateson. It's referred to at paragraph 14 of our printed case. It's volume 1, tab 5. I don't go to it now, but what I do invite attention to in due course is that there is a cross-reference in those judgments to a dissenting opinion by Lord Shaw of Dunfermline in the case of the Crown against Halliday, and the reference to that is volume 1, tab 4. Halliday, time doesn't permit me to go to, as much as I'd like to, because it's a very instructive case, if I may say so. And can I just outline the point very briefly and leave the court to read it in due course? First of all, it has to be acknowledged it's a dissenting opinion, but then, of course, Lord Atkin's opinion in Liversidge was a dissenting opinion, but was later acknowledged to be correct in Westminster by Lord Diplock. Halliday concerned a World War I apparently general measure which permitted, as one would expect, various regulations to be made in defence of the realm. And what the executive had done in that case was to have internment of persons of foreign origin. And the majority did uphold that as being intra vires. Lord Shaw of Dunfermline, if I may say so, provides a powerful speech to contrary effect. And much of what has become known as the principle of legality is, if I may say so, cogently expressed in the opinion of Lord Shaw. And it was then picked up by the divisional court in Chester and Bateson, where, as I've said, they struck down a World War I regulation, which apparently required that before the citizen in a landlord and tenant context could take proceedings before a court, the consent of a minister was required. They said that general words would not authorise that impediment to access to the courts. Now, if anything, if I may say so, in our case, it's even more draconian, because at least there was the possibility of access to the courts with the consent of a minister. Here, there is no effective access to a court to adjudicate on the underlying issues at all. My lords and my lady, at paragraphs 19 to 38 of our printed case, we have set out our critique of the reasoning of the Court of Appeal in the present case in relation to the Al-Qaida order. Now, I don't want to repeat what's said there in more detail, but can I just summarise the position in this way as we understand it? As I apprehend it, the Court of Appeal was implicitly and probably explicitly prepared to accept most of our submissions about the relevant legal principles. What the Court of Appeal, nevertheless, by majority, reluctantly, as I understand it, joined by Lord Justice Sedley on this point, was to say that, in effect, there could be read into the Al-Qaida order the opportunity to have at least some access to an English court. And it was an opportunity to challenge the position of the United Kingdom government, at least. And as I understand it, the Court of Appeal envisaged that if I were successful in such a case, that what the court could then presumably at least declare, possibly order, is that the United Kingdom government should change its stance at the international level and support my delisting. And in our printed case, we've made the observations, my lords and my lady. First of all, there's the obvious point that this is nowhere to be found in the legislative scheme itself. That doesn't necessarily mean it's wrong, but it's a surprising thing to read in. But secondly, and more fundamentally, it's a very curious, as we say at paragraph 30 of our printed case, a curious and artificial form of judicial review, because on the one hand, it is merits-based, unlike conventional judicial review, and on the other hand, the decision which is subjected to review is not the actual decision to designate the affected person. So there could not be, on any view, at the end of that process, a binding decision which would actually lead to the freezing of assets being removed. And my learned friend Mr. Hussein's case of HAY vividly illustrates the problem. He will develop his submissions later today. But in his case, as I understand it, the United Kingdom government supports the applicant and says publicly he should not be on the list. But there's another government. And that could happen in my case, because there were two governments that wanted my client listed, the UK and an unnamed foreign state. So even if the UK government could, by this new procedure devised by the Court of Appeal, make some kind of order against the UK government, it's very difficult to see how they could guarantee that he should not in fact be subject to the freezing of assets regime. And my lords and ladies, we make the final observation developed in the printed case, that this is also a very curious form of judicial review, not least because, as we say at paragraphs 34 and 35, that it's inviting the courts, with respect, to tread in an area where, at least traditionally, they have been very reluctant to tread, namely dictating, as I understand it, to the United Kingdom government how it should conduct diplomatic negotiations at the international level. Now, we certainly for our part would not dispute that in principle that's an area where the courts have slowly and incrementally been prepared to tread, but nevertheless it's another feature of how curious the procedure implicitly devised by the Court of Appeal is. Now, my learned friend Mr. Swift has a much more basic answer to all of this. He says the Court of Appeal was wrong, effectively to accept our fundamental principles. He says, as I understand him, he'll develop this, no doubt, in due course. As I understand it, the argument against me is simply that there is the right of access to an English court, but that actually there's nothing for the English court to review. There is no justiciable legal right in the domestic legal system. I hope, my lord, that I, in answer to my lord's question, gave our response to that. Whether it's a good answer or not will be said in due course by the court.
Mr. Singer, paragraph 39
of our printed case.
Of your case, yes. You emphasise that none of this amounts to a backdoor direct challenge to their Security Council resolution.
Yes.
But I mean,
it doesn't, my lord, for the simple reason, if I may say so, the Cardi judgment acknowledges that the UN Security Council resolution may well be intra vires the Security Council. It may well be perfectly compatible with international law. And yet, if it is to have legal effect within the community legal order, then it's got to comply with certain safeguards. We say, by parity of reasoning, so with basic safeguards in the common law.
But I mean, all right, so they're, for what they're worth, they're effective resolutions, intra vires, but they're worthless because nobody can implement them.
Well, my lord, can I say this? That the argument has often had to be faced in the other direction by individuals. The argument is often, precisely that problem has had to be faced by individuals in the courts of this country in the other direction, where, let's say, you had a UN Security Council resolution, or it may be an unincorporated international treaty, which confers rights on individuals. And it's fundamental law in this country that that's neither here nor there. You can't invoke as a source of domestic law rights against the British state. Now, at the international level, the United Kingdom may then find itself in breach of international law. And that's a recognition of the legal consequence of the concept of dualism, which is the fundamental concept of English law as it treats international treaties and similar instruments. Customary international law may be different, but we're not dealing with customary international law here.
The effect is to frustrate the operation of the Security Council resolution.
My Lord, I make two observations about that. One is not to frustrate it except in an unfair way. But secondly, if that is indeed what the international body concerned has laid down, then I have to say, so be it. Compatibly with our legal system, so be it. My Lord and Lady,
if the European Court of Justice was prepared to take that line.
Lady, if I may say so, I want now, if I may, if it's of assistance, to go to the ECJ judgment in Cardi. That's in volume 13 at tab 105. We looked at the Advocate General earlier. I go now to the judgment of the Court of Justice. Your Lordships and Ladyship will recall that this was a challenge under community law to Regulation 881, which, as it happens, was also the subject of the reference that the House of Lords made in M on a point of interpretation. And this was a regulation, as such, of course, it was directly applicable. So it did not require transposition, as a directive would. It was directly applicable in member states. And it's of some significance, we suggest, that materially the same instrument at the international level has been given effect at the community law level by Regulation 881, and as we now know, has to be read subject to basic human rights in the community legal order, so the ECJ has said. And we submit that at the very least it would be surprising if each member state can then, in effect, avoid those safeguards by having its own national instrument of implementation of materially the same instrument, and do so without equivalent safeguards, natural justice and access to a court being the principal rights. My Lord and Lady, the judgment begins at page 1240, 1240. Initially, the Court of First Instance rejected the challenge, and then the Court of Justice, in the Grand Chamber judgment, reverses that conclusion. The grounds of challenge in the judgments under appeal are summarised at page 1261, paragraph 116. The first was a legal competence point, and the second was breach of several rules of international law by the Court of First Instance and the infringement of certain of its fundamental rights. And the competence point effectively is dismissed on the appeal, and I don't need to take time over that. The point about fundamental rights is dealt with in more detail from page 1277. At the top of that page, and then the findings of the court, as it states them to be, in other words, the reasons on this point, are to be found from page 1280, from paragraph 278. And can I start the citation from paragraph 281? It is to be borne in mind that the community is based on the rule of law, inasmuch as neither its member states nor its institutions can avoid review of the conformity of their acts with the basic constitutional charter, the EC Treaty, which established a complete system of legal remedies and procedures designed to enable the Court of Justice to review the legality of acts of the institutions. It is also to be recalled that an international agreement cannot affect the allocation of powers fixed by the treaties, or consequently the autonomy of the community legal system, observance of which is ensured by the court. It's already been held to form part of the very foundations of the community. At 283, in addition, according to settled case law, fundamental rights form an integral part of the general principles of law. That's a very well-known but basic principle. At 284, it's also clear from the case law that respect for human rights is a condition of the lawfulness of community acts, and that measures incompatible with respect for human rights are not acceptable in the community. And of course, I'm reminded by Mr. Hussain that in paragraph 283, we see the well-known cross-reference to the fact that the court draws inspiration from international instruments and also the community and the constitutional traditions of member states. At 285 on 1282, the court states, it follows from all those considerations that the obligations imposed by an international agreement cannot have the effect of prejudicing the constitutional principles of the EC Treaty, which include the principle that all community acts must respect fundamental rights, that respect constituting a condition of their lawfulness, which it is for the court to review in the framework of the complete system of legal remedies established by the treaty. And the point that my Lord Brown made is perhaps addressed in part at paragraph 286. It must be emphasised that the review of lawfulness thus to be ensured by the community judicature applies to the Community Act intended to give effect to the international agreement at issue and not to the latter as such. And they say at 287, it's not, therefore, for the community judicature to review the lawfulness of such a resolution adopted by an international body, even if that review were to be limited to the examination of the compatibility of that resolution with jus cogens. As I understand it, that's picking up a point the Court of First Instance had made, which had been against the applicants in that case, but had acknowledged that there might be some limitation if the Security Council violated the jus cogens, in other words, peremptory norms of international law which permit of no derogation. Can I continue at 288? However, any judgment given by the community judicature deciding that a community measure intended to give effect to such a resolution is contrary to a higher rule of law in the community legal order would not entail any challenge to the primacy of that resolution in international law. To my Lord Brown, I would say that that's my answer to the question posed earlier.
It's very odd there's no reference at all to Article 103, isn't it? I mean, the point just isn't faced as to whether nations can, as it were, agree that any subsequent treaty they may conclude is going to be subordinate.
I wouldn't dissent from that point, my Lord, but I'll give an answer to it, which is that in international law, standing back from this judgment for a moment, it's not rare for there to have to be resolved, potentially incompatibility between different international treaty provisions. Take the obvious example the courts are very familiar with of asylum law, where there may well be an obligation to return someone, let's say pursuant to a refugee, to an extradition treaty. But both Refugee Convention law and Human Rights Convention law potentially inhibit. So the tension between different obligations, even at the international treaty level, is not a new problem. It has to be resolved somehow. And ultimately, I suggest the answer turns on this, that you have to ask, what is the relevant court, and what is the relevant legal system of which it's a member, and therefore what is the relevant law which it has to apply. And it may be that different answers have to be given at different levels.
Is Article 103 not meant to be the trump card in the United Nations' hand?
At the international level, Lord, yes. But rightly or wrongly, the Court of Justice is saying that the European legal order is, as is often said in the past, it's a supranational, it's a sui generis system of law, not a traditional international treaty at all. Now, it's no part of my case to say that it's necessarily right. As a matter of community law. It's what they've said, it's authoritative. But what I do rely upon it for is that the legal reasoning in it is persuasive if it's transposed to our common law and constitutional arrangements. My Lord.
Yes, I mean, your basic point is that the European Court is applying European law.
Yes.
And in the eyes of European law is supreme. It's not a United Nations court, just as the German Constitutional Court would say, or the French Constitutional Court perhaps would say that it was applying its own order, supreme in certain respects, which probably the European Court wouldn't accept.
I would accept that. Yes. Lord, returning, if I may, to the citation from this judgment, can I go to paragraph 298? Obviously, all of it's important, but I'm taking it quickly in the interest of time. Paragraph 298, it must, however, be noted that the Charter of the UN does not impose the choice of a particular model for the implementation of resolutions adopted by the Security Council, since they are to be given effect in accordance with the procedure applicable in that respect in the domestic legal order of each member of the United Nations. The Charter leaves the members of the UN a free choice amongst the various possible models for transposition into their domestic legal order.
Well, that's fine. That goes to how you transpose, but not to whether you do.
No. And again, that comes back to the point about is it binding at the international level. But I accept my Lord's point. There is a tension here, undoubtedly. It follows from all these considerations that it is not a consequence of the principles governing the international legal order under the UN that any judicial review of the internal lawfulness of the contested regulation in the light of fundamental freedoms is excluded by virtue of the fact that measure is intended to give effect to a resolution of the Security Council adopted under Chapter 7. And then, importantly, at page 1285, the Court of Justice cross-refers to a judgment of the Court of Human Rights in Bosphorus at paragraph 313. Now, I will return to Bosphorus, upon which Mr. Fordham has rightly placed emphasis when I address the Court on Al-Jeddah, but for the moment, can I simply note that it is expressly referred to and endorsed here. And then at 317, at the bottom of that page, the question of the court's jurisdiction arises in the context of the internal and autonomous legal order of the community, within whose ambit the contested regulation falls, and in which the court has jurisdiction to review the validity of community measures in the light of fundamental rights. And then at 321, in any event, the existence within that UN system of the re-examination procedure before the Sanctions Committee, even having regard to the amendments recently made to it, cannot give rise to generalised immunity from jurisdiction within the internal legal order of the community. And then at 323, they really pick up the Advocate General's point that even having regard to the focal point procedure, the fact remains that the procedure before that committee is still in essence diplomatic and intergovernmental, the persons or entities concerned having no real opportunity of asserting their rights, and that committee taking its decision by consensus, each of its members having a right of veto. The 2007 guidelines, which I took the court to, are then summarised in the following paragraph. And at 326, the court states, it follows from the foregoing that the community judicature must, in accordance with the powers conferred on it by the EC Treaty, ensure the review, in principle the full review, of the lawfulness of all community acts in the light of the fundamental rights forming an integral part of the general principles of community law, including review of community measures which, like the contested regulation, are designed to give effect to the resolutions adopted by the Security Council under Chapter 7. My Lords, then and my Lady, there's a heading concerning the actions before the Court of First Instance from 331, and at 333 the Court states that in particular it's going to examine first the claims made by Mr. Cardi and Al-Barakat about the right to be heard and of the right of effective judicial review, which are the mainstay of my argument as well. And at 334, they say, in this regard, the rights to be heard and the right to effective judicial review of those rights were patently not respected. And at 336, after the citation of cases, they state, it must be held in this instance that the effectiveness of judicial review, which it must be possible to apply to the lawfulness of the grounds on which in these cases the name of a person or entity is included in the list forming Annex 1, means that the community authority in question is bound to communicate those grounds to the person or entity concerned, so far as possible, either when that inclusion is decided or, at the very least, as swiftly as possible after that decision, in order to enable those persons or entities to exercise their right to bring an action. That's really the duty point about post-decision fairness if pre is impossible.
And why did Brussels produce this regulation? I mean, why do they do that? I mean, everybody had the United Nations resolution.
That's not entirely clear to me. I don't know, my Lord. It may be something that my learned friends can assist on. There was, your Lordship may recall in the judgment of the Master of the Rolls, there's a reference to a first instance decision by Kenneth Parker, as he then was, as a deputy judge, in the M case, where Mr. Parker had speculated that the reason why a dual-track approach was taken, because it may have been feared that at one level the instrument might be struck down. The Master of the Rolls said that that wasn't particularly helpful to speculate in that way. Who knows? Well, I don't know.
I mean, how does it work here? Sometimes we operate under the regulation. Obviously, we did in the case that we've referred to Luxembourg.
Well, quite, my Lord. It's a point I know that Mr. Fordham wants to develop. But I don't need to go perhaps as far as he will wish to go in due course. But what I do say on behalf of my client is that it's at the very least legally surprising that you can have the very same UN instrument apparently being implemented at the community level by Regulation 881, at the domestic level by the Al-Qaida order, and that even though the regulation is directly applicable, and now we know is subject to these important legal safeguards, that apparently, if the Treasury's argument is right, the UK government could in effect bypass those safeguards by proceeding under its own implementing measure. Now, I say that it doesn't have that effect, and the reasoning in Cardi should be adapted and adopted by parity. My Lords and Lady, the surprise point, which I do, of course, realistically accept, is a valid consideration against pre-decision fairness, is made by the court at paragraph 340 at the bottom of the page we were looking at. But having considered that, they say at 343, however, that does not mean, with regard to the principle of effective judicial protection, that restrictive measures such as those imposed by the contested regulation escape all review by the community judicature once it is claimed that the act laying them down concerns national security and terrorism. It's nonetheless the task of the community judicature to apply, in the course of the judicial review it carries out, techniques which accommodate, on the one hand, legitimate security concerns about the nature and sources of information taken into account in the adoption of the act concerned, and on the other, the need to accord the individual a sufficient measure of procedural justice. That's the balancing point, which I've already acknowledged. In principle, Parliament has sought to achieve that, for example, in the context of control orders. It may be the balance wasn't struck in exactly the right place with hindsight, but there it is.
Was reasonable suspicion the basis of 881?
Mr. Hussain tells me that it's not, but I'll allow him to develop that if he wants to come back to it.
Why aren't you running the argument which Advocate General Juarez Maduro floated in paragraph 30 to the effect that if the community measure was invalid, then since member states in the field of security policy are obliged to act in a manner consistent with community law, it was to be assumed that to that extent at least they would be subject to the community rules for the protection of fundamental rights and could not pass measures nationally which had been held invalid at the community level. Well, that's an ingenious argument. Why? It isn't being run, though.
No, Lord, Can I answer that in two parts? And just to be frank with the court. When this case was started, this is the history of it, the first part of the answer is, the history was, it was a very bleak legal landscape we were facing because of the Court of First Instance judgment. Yes. So we've made the case under common law for that pragmatic reason. But secondly, and more importantly, at the level of principle, it may be that now that is an argument open to me, and if I need it, I do rely on it. Mr. Fordham certainly, I think, wants to
I think it's very difficult to rely on it out of the blue like that. I mean, I only mention it because I spotted it.
I don't need
it's an extremely difficult argument, the interchange of or relationship of competence.
Well, my Lord has the point. We say we don't need it. No. We firmly root our case in the common law, and as your Lordship knows, I rely on this judgment simply for this reason, that it provides a persuasive piece of legal reasoning, albeit transposed to a different legal system.
Well, I suppose you can also say, whether it's right or not, I don't know at the moment, that if the EU can do it,
yes.
Yes. And the respect for fundamental human rights is almost as implicit, so to speak, in the community legal order, yes. As it is in the UK's constitution, yes. And then why can't this court do it?
Well, my lady, by parity of reason, that's the sort of argument I'm seeking to advance.
I mean, Cardi has been quite a contentious decision. We haven't seen any commentaries on it, but it was both the Advocate General's opinion and the court's opinion were greeted in some circles with surprise, and it might be interesting to see some of the commentaries.
Yes, there are some commentaries in the bundles of authorities that the parties have jointly produced, but it may be that I can give better references after the short adjournment.
Can I mention, as far as the reach of 881 is concerned, if you look at page 1221, the Advocate General, paragraph 7, quotes from the contested regulation, and it looks as though it depended entirely on designation by the Sanctions Committee for its application, so the reasonable suspicion point wouldn't arise. If that, I mean, that may be incomplete, but at first sight it looks as though it isn't dealing with that problem.
That's my reading of it as well. It may be that my understanding is incomplete, but I do accept that point, my Lord. On the face of it, that appears to be right.
So it's only people designated by the 1267 committee that are caught, is it?
That seems to be the effect of the regulation.
I see.
Yeah. So the national state, in its legislation, on the face of it, has gone somewhat further than that, because it allows for the possibility, under the Al-Qaida order, of a direction by the Treasury.
That's our legislation.
Yes.
I'm sorry.
Our legislation, you mean?
Yes, our legislation.
Was M, the one we referred, was he somebody who was designated by the 1267 committee?
Yes, it was. Well, that concerned the families. So the applicants were the members of the families.
But, yes, but he had been.
There's certainly... Can I say that? I'm just checking with Mr. Hussain that I am permitted to say to the court that M is the spouse of H-A-Y.
Sorry, M is H-A-Y.
I was going to ask.
M-M.
I was going to ask whether there was any overlap between
the initials M-M, because there's a case known as M-A and M-M, and that person, M-M, is the wife of Mr. H-A-Y. It's the person known as just M, I'm told. It probably doesn't matter.
One of them, anyway.
One of them is.
So the designated person who underlay the M legislation, the M case,
analytically, it's the same situation.
I see.
There's a 1267 designation. You then have in that case the regulation being relied upon, and the case didn't itself concern the national measure. Yes. I'm reminded by Mr. Hussain that Regulation 881 can be found by reference in Volume 19 at tab 180. if one just briefly wants to go to that, it deals, I think, with my Lord Hope's point that it simply transposes the UN list and it doesn't go further than that. That's Article 2, paragraph 1. The odd page, the second page of the regulation behind tab 180.
It's also quoted in Lord Bingham's judgment in,
yes.
in M.
I'm grateful to be reminded of that, yes. Thank you. Can I return then to the court's judgment in Cardi? We've nearly finished the material passages. And I'd got to page 1289 at paragraph 345, where the court states, in the circumstances, the inevitable conclusion is, first of all, that neither the contested regulation, nor I think it must be the common position, provides for a procedure for communicating the evidence justifying the inclusion of the names of the persons concerned in Annex 1, either at the same time or later. And at 348, they conclude in the last line, therefore the appellant's rights of defence, in particular the right to be heard, were not respected. In addition, given the failure to inform them of the evidence against them, the appellants were also unable to defend their rights with regard to that evidence in satisfactory conditions before the community judicature, with the result that it must be held that their right to an effective legal remedy has also been infringed. Can I just place emphasis on those words, effective legal remedy? Because it's a point I know Mr. Hussain is going to develop, but it's a point common between us, and obviously we sought to avoid duplication of argument. And the point is simply this, that as I understand him, Mr. Swift will submit that in our case there is a right of effective access to the court, but we say that it means much more than simply being allowed through the court's door. It must mean, as is put in both human rights law and in community law, it's the right to an effective legal remedy. And then they continue at 350, last it must be stated that that infringement has not been remedied in the course of these actions. They then say that they will, having found that to be well-founded, they will examine from 354 Mr. Cardi's plea with regard to breach of the right to respect for property, and they do a balancing exercise. Now, this is very much what Bosphorus recommends needs to be done. And it's very familiar territory, similar to Article 1 of the first protocol. So there's an interference, they examine whether it's justified. And eventually, on the facts, that 370, they conclude that in the circumstances of the case, the interference there constitutes an unjustified restriction of his right to property. So they found the substantive right to respect for property also well-founded, that complaint was well-founded. And so they ordered that the contested regulation, so far as it concerns the appellants, must be annulled. Now, before I leave this, my lords and lady, can I just make this observation? That, of course, one of the functions of a court of law, if it is allowed to adjudicate on a dispute between the citizen and the state, will often be, where there is an interference with human rights, is to adjudicate on whether that interference is justified or not. So questions of proportionality often arise, and they will turn on the circumstances of each case. And what the court is emphasising is an element, it's not the only element, but one of the elements of the right of effective access to a court, what they call judicial protection, must, we submit, include the ability of a court to adjudicate upon that sort of question. It can't just be precluded from deciding on the facts of the given case. Like we've seen in Mr. Cardi's case, they descend to the detail of the individual interference. Now, in principle, they might have concluded that the interference in that case was justified. So we're faced with the fundamental preceding situation, which is that a court of law is never allowed to embark upon that exercise. And that's, we submit, an invasion of the right of effective access to the courts.
Sorry, when you say it's never allowed, I mean because it hasn't got the underlying material.
Yes, and on the Treasury's case, the Al-Qaida order simply has the effect that you're on the list. In a sense, it's an automatic exercise. You just ask, are you on the UN list? Answer yes. And whatever the impact on human rights, however unjustified and disproportionate it may be in the individual case, there's nothing for a court in this country to adjudicate upon.
You could have, in theory, have a situation where all the relevant facts had actually been disclosed.
Yes.
It wouldn't help to say, well, having considered all these facts, we can see no justification for you being on the list. The answer is, well, tough.
Exactly.
You're on the list.
My Lord is right, and Mr. Hussain will be saying that's his case.
Well, that's the position actually in Hay,
It is,
except that it's not the court who said it, it's the Crown who said it.
That's right. But, my Lord, to test the legal principles, I would respectfully suggest it's worth examining the scenario slightly different, where the UK government is prepared to disclose its case. Let's say it can be found through a special advocate and a closed hearing, and assume it's all fair, according to Article 6, and the court reaches findings of fact which are adverse to the UK government. It's an important limitation we submit on the right of effective access to the court, that even in that scenario, on the Treasury's case, the court in this country does not have the legal power to grant any binding remedy. And that's an extraordinary thing for a court to be. It raises jurisprudential arguments about whether one can truly say that that is a court of law. That probably doesn't assist in this context, but it's a very odd kind of court. My lords and my lady, unless there are further questions on the first principal ground of appeal in our case, what I would like to do now is to turn to the alternative argument, if I need it, based on the Human Rights Act. We have developed this in our printed case at paragraphs 51 to 67. And, of course, it's right that I should immediately acknowledge that Al-Jeddah may be, on one view certainly is, against me. Can I take the court to Al-Jeddah then, please? It's in volume 8 at tab 64.
5-4?
64.
64, sorry.
Volume 8, 64. Now, 3 members of this court were members of the House of Lords in that case, and the facts will be familiar to all members of this court. They did arise out of the British occupation of southeastern Iraq in 2003 and 2004. But although, and this is an important part of my submission to this court, although factually the case arose out of events outside the territory of the UK, as I understand it, that fact plays no part in the legal reasoning which the court, the House of Lords in that instance, eventually leads to its conclusion against the applicant in that case. And my lords and my lady, that, of course, is because it was one of those relatively unusual cases where jurisdiction within the meaning of Article 1 of the European Convention was being exercised by the United Kingdom in Iraq, at least to the extent that they were detaining an individual in a British custodial facility. Now that their Lordship's House had decided in the earlier case of Al-Skaini, and had also decided by majority, meant that the Human Rights Act was applicable. And that's how the case comes before a court in this country.
I mean, there was another point in the case.
Oh, absolutely.
Whether, in fact, it was UK detention or United Nations detention.
And there was a difference.
And by a majority,
it
was held to be UK detention. But we're not concerned with that.
Your Lordship, I know, will forgive me. I was going to say that there were 3 main legal issues before their Lordship's House in Al-Jeddah. The first was what was known as the issue of attributability, on which, as I understand it, my lords, Lord Roger and Lord Brown, were in a minority. That's not relevant.
Well, I hedged my bets on that one.
Yes, you did. Yes, you did. I've seen the postscript. The majority said attributable to the UK, not, for example, to the UN. The second issue is the one that we're directly concerned with, and I'll look at the reasoning in a moment, if I may, which was what is to be done where, on the face of it, there is a conflict between two international treaty obligations. On the one hand, Article 5.1 of the European Convention, and on the other, the UN Security Council resolution, tied as it was to the power of internment, which is acknowledged in Article 78 of the relevant Geneva Convention. In occupied territories, on the face of it, there is that power of internment. And the third issue, which again doesn't arise in the present case, was what the applicable law was to an action for false imprisonment. And in the end, it was held on a conflict of laws resolution of that issue, that it was Iraqi law rather than the English common law which governed. As I understand it, it was not English law. Mr. Hermer was in the case with Mr. Fordham. I was not. But as I understand it, there were then subsequent proceedings on that, and they were resolved by the High Court in due course. But it's
so this claim was founded exclusively on the Human Rights Act.
Exactly. And so, my Lord, that's why, first of all, I don't necessarily need to challenge Al-Jeddah. If I can succeed, as I say I should, on the arguments I've made so far this morning, then this court will not have to address the question of whether it should depart from Al-Jeddah. But if I need the Human Rights Act, then I am squarely faced with the problem that, on the face of it at least, Al-Jeddah is against me. And on that, as I understand it, the judgments, possibly with varying degrees of enthusiasm, were unanimous. Can I show the court the reasoning on that issue, then? The first opinion was that of Lord Bingham, starting at page 337, and his lordship turned to this issue at page 349, at paragraph 26, which has the heading, the second issue, and noted the provisions of Article 103 of the UN Charter at paragraph 30. There was then an argument deployed by Mr. Starmer on behalf of the appellant there about whether there was a distinction to be drawn, as I understand it, between a resolution which mandates something and one which authorises something. That debate, suffice to say, ended in a resolution against the argument for the appellant. And it
on
is
the basis
right,
that, in effect, it was a mandatory requirement.
Exactly. It's right to note that Bosphorus is referred to at paragraph 33, but it's a point that I know Mr. Fordham makes on behalf of justice, that although Bosphorus is referred to in a number of their lordships' opinions, he would submit, as I understand it, that it's not really referred to for its central principle, which he has described as the principle of equivalence of human rights protection, and I'll let him develop that later today. At paragraphs 35 and 36, Lord Bingham noted that emphasis has been placed on the special character of the European Convention as a human rights instrument. But he took the view that reference in Article 103 to any other international instrument leaves no room for any accepted category, and such appears to be the consensus of learned opinion. And then at 36, his lordship said, I do not think that the European Court, that is the Court of Human Rights, if the Appellant's Article 5.1 claim were before it would ignore the significance of Article 103 of the Charter in international law. The Court has on repeated occasions taken account of provisions of international law, invoking the interpretative principle laid down in Article 31 of the Vienna Convention, acknowledging that the Convention cannot be interpreted and applied in a vacuum, and recognising that the responsibility of states must be determined in conformity and harmony with the governing principles of international law. At 37, a countervailing point was acknowledged. The appellant is, however, entitled to submit, as he does, that while maintenance of international peace and security is a fundamental purpose of the UN, so too is the promotion of respect for human rights. On repeated occasions in recent years, the UN and other international bodies have stressed the need for effective action against the scourge of terrorism, but have in the same breath stressed the imperative need for such action to be consistent with international human rights standards, such as those which the Convention exists to protect. And the well-known case of Waite and Kennedy in Strasbourg is quoted from. The problem in a case such as the present is acute, since it is difficult to see how any exercise of the power to detain, however necessary for imperative reasons of security, and however strong the safeguards afforded to the detainee, could do otherwise than breach the detainee's right under Article 5.1. The possibility of derogation is then referred to at 38, but not regarded by Lord Bingham as a satisfactory solution to the conundrum. And noting, for example, at H, it's not been the practice of states to derogate in such situations, and since subsequent practice is relevant to interpreting a treaty under the Vienna Convention, it seems proper to regard Article 50 as inapplicable. I do want to come back later in my submissions to that concept of derogation and invite some reconsideration, at least in the context of an ordinary peacetime situation in this country. But let me explain that later, if I may. Just continuing with the citation for now, 39, Lord Bingham states, "Thus there is a clash between, on the one hand, a power or duty to detain exercisable on the express authority of the Security Council, and on the other, a fundamental human right which the UK has undertaken to secure to those like the appellant within its jurisdiction. How are these to be reconciled? There is, in my opinion, only one way in which they can be reconciled, by ruling that the UK may lawfully, where it is necessary for imperative reasons of security, exercise the power to detain authorised by the Security Council Resolution 1546, but must ensure that the detainee's rights under Article 5 are not infringed to any greater extent than is inherent in such detention." I would resolve the second issue in this sense. So if I may fairly summarise how I understand Lord Bingham's speech, his lordship clearly agonised over this and found it a very difficult legal problem, faced with this apparent clash with a fundamental right of liberty in Article 5.1, which had not been derogated from, and on the face of it was therefore as applicable in a cell in Iraq as it would be in a cell in Paddington Green. Nevertheless, doing, as I understand it, his best to reconcile this with the obligation to comply with the UN Security Council resolution, and having regard to the apparently overriding effect of that resolution under Article 103 of the UN Charter. Implicit in this reasoning, as I understand it, is that Lord Bingham took the view that if the case had been decided in Strasbourg, that the Strasbourg court would interpret Article 5 by reference to international law more generally, and therefore that's the way out of the conundrum. If that's right, then because the Human Rights Act mirrors Strasbourg, so the House of Lords held no breach of the Human Rights Act in a domestic court either.
What does the qualification, not infringed to any greater extent than is inherent in such detention, actually mean in practical terms? I mean, firstly, you can be detained
My Lord, as I understand
where necessary for imperative reasons of security. So what does it mean?
My Lord, what it means, as I understand it, and it's a point that was elaborated on by my lady, Baroness Hale, and also Lord Carswell later, as we'll see. But essentially, as I understand it, the point comes down to this. The fact of detention is authorised, and there's no getting around that. And so to that extent, there's a breach of Article 5.1, although it's not a breach. But that doesn't mean that you, for example, aren't entitled to the procedural safeguards. So you can take your case to a court afterwards under Article 5.4, test the evidence.
To see whether it was necessary for imperative reasons of security to...
Yes, yes.
Doesn't it, in effect, add a ground to the list of permissible grounds under Article 5.1?
Exactly.
But
another
element in not infringed to any greater extent must also include the duration of the detention, mustn't it? And one thing that worries me repeatedly about this case is we keep being told that freezing is not criminal but preventative.
Yes.
And
yet apparently
sometimes it's said temporary, and there seems to be precious little element of reviewing whether it's still necessary.
Well, my Lord, I would respectfully endorse that observation, if I may. It's a point Mr. Owen made, I think, yesterday, that this is actually nothing like some of the primary legislation that he's shown your lordships and your ladyship, which could be regarded on one view as temporary. This is a permanent, indefinite freezing of all property and economic resources in the widest sense. And as the court is very well aware, we're not talking in these cases of, as it were, wealthy mafiosi or the like. We're talking about ordinary people who need a license even to go shopping at Tesco. My lords and my lady, can I take the court next to the opinion of my Lord Roger? On this, can I draw attention to page 373, where my Lord came to his concluding paragraphs on the first issue at paragraph 114. And my Lord said there, that being my conclusion on the first issue, that was attributability. The second issue does not arise for determination. On that matter, I am, however, in substantial agreement with Lord Bingham. I had only these short observations. And again, in fairness, I should observe that Bosphorus is referred to at the end of paragraph 115. But as I understand it, Mr. Fordham will develop on behalf of Justice a submission about to what extent Bosphorus was really fully dealt with in this reasoning, if I may say so with respect.
I think paragraphs 51 and 52 of Lord Roger's speech touch on a point that we were considering earlier this morning.
I'm grateful to my Lord. Yes, if I can just...
The reference to McCurr.
Yes, I'm grateful. McCurr is the well-known decision of their Lordship's House that effectively there is it is right to acknowledge that the Human Rights Act as a domestic statute creates domestic law rights. But as other cases have said, my Lord is very familiar with Ulla and Al-Skani, they should in general reflect on the mirror principle. McCurr is in volume 6 at tab 46 for reference. Volume 6, tab 46. Thank you. Going back to the opinion of my Lord Roger, if I can perhaps just deal with that.
Yes.
Can I finish that before the short adjournment? My Lord, simply to say that submission on the second issue for the appellant was also rejected in briefer terms than Lord Bingham at paragraph 116 to 118, with a conclusion at 118. Had it been necessary to decide the point, I would accordingly have held that by virtue of Articles 25 and 103 of the Charter, the obligation of the United Kingdom forces in the multinational force to detain the appellant under Resolution 1546 prevailed over the obligations of the UK under Article 5.1 of the European Convention. Of course, I need to deal with the other opinions. May I do that briefly after the short adjournment?
Yes, we'll adjourn now.